Welcome back to the day one session in the 14th annual Business Law e-conference of the MBA SBL. We hope you've been having a wonderful time with us. We're moving now to our fireside chat with Mr. A.G. Abubakar, the Registrar General of the Corporate Affairs Commission. The topic for discussion in this session is changes on the horizon, the future of company law in Nigeria. Good afternoon, sir, and you're welcome to the conference.
Good afternoon, Adolfo. Thank you so much.
Thank you for. You're welcome. Thank you for taking the time to be with us and to answer some of our questions. As you know, the Corporate Affairs Commission is right at the center of what we're discussing in this conference, which is really how we're taking corporate law and the practice of business law in Nigeria forward. And so we'd like to go straight to some of the questions we have for you today. With the impact of COVID-19 and the shift to a digital way of life, Nigerian companies are trying to keep doing business, but they keep facing obstacles with respect to complying with certain statutory obligations, such as filing returns at the Corporate Affairs Commission within a specified time frame, holding general meetings, etc. What steps have the CAC taken to digitize, and how has that helped companies through this challenging period?
Thank you very much for that question. We've had very checkered history in our digitization drive. As you may know, we started using electronic workflows for our registration services in 2004. We ought to have perfected the process by now, but unfortunately, we are yet to do that. As of today, to register a company, you can start and end the process electronically, but you need to visit CAC to collect your documents after incorporation. For post-incorporation, the process is still manual. Customers have to visit CAC to submit documents, to file returns, to change directors. This is not good enough. We've had issues with the software vendor that was actually engaged in 2014 to develop the application. The contract provides for an end-to-end electronic solution that will cover the lifespan of the company from name reservation to dissolution. Unfortunately, the entire application has not been developed. Only about 40% has been built. We've given them, and with the COVID pandemic, we're actually on the spotlight because it has brought to fore the whole essence of having a digital process. So we've called back the vendor and made it clear to him that he has a deadline of August, the end of August, to finish the entire application. If they cannot do that, then the commission will be forced to look for other vendors. Incidentally, we have other interventions coming from the old bank on the persons with significant control register. That is the beneficial ownership register. The World Bank has approved a grant of $400,000 under the OGP multi-donor fund. Very soon, we are going to start the procurement process. So also, the new legal arrangements we are going to have of limited partnerships and limited liability partnerships, which will require a whole new application. We do not intend to engage the same vendor to develop that application. So we want to open it up, get a very reliable vendor that has the wherewithal to develop that application. So as soon as we do that, if we succeed in getting somebody that has the necessary skills, then it will be easier to get them to extend that application to cover the whole gamut of our operations. So for AGMs, CST, together with the Nigerian Stock Exchange and the Securities and Exchange Commission, had a meeting just before the lockdown was announced to devise ways of mitigating the impact of the lockdown, particularly for companies that were planning to hold their annual general meeting. CSE had to come out with guidelines to allow proxies in such meetings instead of calling the entire shareholders of the company. We've seen how this thing has gone. It has been quite successful. Up to yesterday, we're still receiving applications from companies for them to use proxies. And the number of proxies allowed is usually up to 20. Some companies are using 4, 5, which is still allowed. And initially, we thought we will have some resistance from the shareholders, but it has been accepted generally, and we are not facing any challenge. Moving forward, I think with COVID, it has shown us that the way forward is actually to have a digital process, not just for our own filings and other engagement with CAC, but also in the company's day-to-day operations. Companies should be able to hold their meeting as we are doing now at the SBR. But because the law is silent on electronic meetings and the requirements relating to notices and other things, we cannot just go ahead to public companies that have thousands of shareholders to have electronic meetings. But for private companies, we've been encouraging them to hold such meetings, and we've also encouraged them to amend their articles to allow for electronic meetings. So these are some of the things. For us, what we have tried to do is we are facing a lot of challenges because of the guidelines of the federal government that only level 14 officers and above should come to work. And offices are open from 8 to 2 p.m. So you have to close 2 p.m. The level 14 officers in our employment constitute less than 25% of our total workforce. So you can imagine having such number of staff, limited number of staff to treat applications that come in on a day-to-day basis. We have to recall some other stuff that we regard as essential. What we are trying to do now is to introduce a mailing system. Where we have the greatest challenge now has to do with dispatch of documents. When we treat applications in good time, but to get them dispatched, because our officers have to close at 2, you don't get customers, you can't keep customers in your premises up to 2 o'clock, after 2 o'clock. So we are trying to have an arrangement with courier companies, particularly in Lagos and Abuja. Some of such certificates, CTCs, and such reports can be delivered to customers in their homes and offices. So we are working out the arrangement, and hopefully by the first week of August, that arrangement will come into effect. So these are some of the things we put in place, and hopefully we've also recognized the need to enable our staff to work from anywhere. So we are acquiring laptops. We have just obtained approval to acquire laptops so that staff can work from home. At least if officers below level 14 cannot come to the office, they should be able to work from their homes and render services to customers. So we are acquiring laptops such that at least we can go back to our service timelines. At present, we had to suspend the service timelines because we cannot cope. You have less than 30% of the staff coming to the office. They can only work from 8 to 2. So it has been quite difficult. But there are opportunities in all this because it's an opportunity for us to have an end-to-end digital process that you render services without having to see the customer. So this is actually what we have been doing, and hopefully some of these things will be achieved before the end of the year.
Thank you. Thank you so much, RG. I just want to remind our delegates that we have a poll open. So on the Hopin page, please go to the poll link, the poll section, and respond to the poll. We're going to be taking the results of the poll at the end of this session with the RG. A lot of the things you've said, RG, they're very comforting to hear. It's good to see that the CAC is, embracing technology and forward thinking. And also your references to limited partnerships and the things you're looking forward to doing in the future has led to my next point, which is about the bill to repeal and replace the Companies and Allied Matters Act. We understand that this bill has been passed by both houses of National Assembly and was due to be harmonized and sent for presidential assent just before the pandemic. So that slowed the process down somewhat. There's a lot of anticipation about this bill within the business law community, as it's expected that the bill will propel Nigerian company law into the 21st century and equip Nigerian companies to compete in the digital age. In your opinion, is this expectation justified? And if so, what are the innovations of the bill that you are most excited about?
Thank you so much. Incidentally, the moderator was also part of the process because you actually chaired the NASBA committee that came up with the first draft. Well, I'm pleased to announce that the bill was actually transmitted to Mr. President last Friday, and it has already been circulated to all the key agencies for their comments. We've sent back our comments to the presidency today. Yesterday, I spoke with the special advisor to the president on this of doing business, and she confirmed to me that they were also sending their comments today. So we've been contacting other agencies that are required to send comments to get them to do so in good time. The good thing about it is they give you a time frame within which to send the comments. If you do not send, then it's deemed that you don't have any comment. The expectations are actually genuine, and this will change the whole framework of our company law in so many areas, right from the capacity to form a company. At present, a company must have minimum of 2 shareholders. One person cannot register a company, but that has changed. One man can now form a company, and you can have a single director in a company. The second issue relates to, this will affect a lot of us lawyers, because for most lawyers, the requirement that a legal practitioner must depose to a declaration that the requirement of the law has been complied with before the company can be registered, that has been removed, because we are talking of ease of doing business. And in actual sense, in the company formation process, the legal work is very, very negligible. The legal work is mostly in advisory services after the company has come into existence. And most of us we don't even prepare this memorandum and articles ourselves. We take it to business centers, they do copy and paste, they submit to CAC with all the mistakes that you have. So that requirement has actually been removed. Once a statement of compliance is made by one of the directors, then we are set to go. The company can be registered. Another change has to do with the issue of authorized share capital. That has actually been abolished. So the company has to register with actually the issued share capital. I have mentioned the new legal arrangements, limited partnership, limited liability partnerships. We also have a new concept on beneficial ownership. Although for us, we adopted the UK model of persons with significant control. Because of concerns of money laundering and terrorism financing, the attention of the world has shifted to identifying the ultimate beneficiaries of companies. So in other jurisdictions, you are supposed to disclose the beneficial owners of the company. We know what happened with Panama Papers, where companies were registered by lawyers without disclosing the ultimate beneficiaries. So under the new legal framework, we have a threshold of 5% of shares or voting rights. Once a shareholder has up to that, then he must file that declaration, that statement with the company, and the company must in turn file that statement with the CAC. Immediately, somebody qualifies as a PSC, or whenever they are filing annual returns. We are going to have an independent register of beneficial ownership. That one will be publicly available. These are part of the commitments the federal government made under the Open Government Partnership, as well as the Extractive Industry Transparency International Initiative. That Nigeria, and Mr. President also made that commitment during the 2016 London Development Summit, that Nigeria will introduce a publicly accessible register of beneficial ownership. So to give effect to this commitment, CIC is going to have a register of beneficial ownership free of charge, to be in open data format. Anybody that desires to obtain information from that can do so. Other changes has to do with the legal framework for incorporated trustees. You will all agree that the provisions are very scanty. What they did in 1990 was just to move the provisions of the Land Perpetual Succession Act without any change. We have borrowed a lot from the provisions of the Charities Act of the UK. We have provisions now for merger of incorporated trustees, and the power of CAC to suspend a trustee where there is allegation of fraud or in the public interest. And the courts can also intervene to suspend the trustees or the officers of such associations. So there are a whole gamut of provisions, and I believe it will serve the business community well. We have a new legal arrangement, a new provisions on company voluntary arrangement. You will all agree that the current insolvency framework is actually a hostile framework that is always at the mercy of the lender. The company hardly has any opportunity to come out with an arrangement to resolve the insolvency. And you will also agree that most companies that go through receivership, they hardly survive those receiverships. So we have a new framework on voluntary arrangement that will allow the company to apply to appoint an administrator that will manage the company to take care of the needs of employees, the needs of the creditors, and other stakeholders. So, for the first time, the law recognizes insolvency practitioners and accreditation of insolvency practitioners by the CAC. So, BRIFAN will collaborate with BRIFAN and other relevant bodies to come out with a framework for that. We're also going to have an administrative proceedings committee where you have protracted disputes in companies. Our major concern has to do with disputes relating to names, as to what constitutes similarity, because we've had that kind of issue. Somebody wants to proposing a name, another person is saying that, oh, this name is similar to my own. The matters end up in court. Sometimes the judicial process takes a long time. But with the Administrative Proceedings Committee, you can easily resolve some of these disputes within a very short time. So these are some of the changes we're anticipating. There are so many that I cannot exhaust them at this sitting.
Yeah. Thank you so much, Mr. RG. I think I will ask you my last question before we take some of the questions that have been put up in the chat and also discuss the outcome of the poll. You were confirmed as the substantive RG of the CAC in January 2020, and at the SBL, we are particularly proud that one of our council members is at the helm of the CAC. So please accept our congratulations on this well-deserved achievement.
Thank you so much.
What can we look forward? You're welcome, sir. What can we look forward to seeing at the CAC? You've already touched on this, but if you could just shine a bit of focus on what innovations you have in store for us, because we expect that based on all you've said, the changes you are introducing, and some might be as a result of the pandemic, but it seems like you are on a drive to institutionalize a lot of change. So what innovations do you have in store? What can we expect to see?
Thank you. The major innovation has to do with an end-to-end digital process, that a company can manage its own account the same way you manage your email account without having to leave your home or your office or leaving your device. Every company is going to have a unique account. We'll create a username and a password. They can make their filings through that medium. By the time we are done, there won't be any need for any physical documents to be submitted to CAC. You can do your documents, even the need for signature in certain cases may not be necessary. If you are changing directors, we may not require a resolution. You just fill the relevant forms and submit by electronic means, and that will be recognized. Provided that filing is made through that account, you don't need to visit CAC to do it. And for anything at all, even searches that we are doing now, physical searches in CAC, which CAC has suspended, we want you to be able to sit in your office or your home, view all this information, pay and view all the information. If you require certified true copies, you pay electronically. We send it to you with a validation code that the person dealing with you can validate. So the CAC of the future we are looking at is a CAC that you can interact with electronically. Every company will have its own unique password and username. They can give access to multiple people. They can give access to their own solicitors. But we will have a window. We recognize that there may be third-party transactions that may not necessarily come through the company, where a receiver is being appointed or where liquidation is being filed, that may not come through the company. So there will be that window for lawyers, accountants to be able to make these filings. Another thing we are looking at is submission of financial statements. We are looking at introducing extensible business reporting language for financial reports, such that the auditor, after the account is approved, the auditor will submit through an extensible platform. This will help for statistical analysis, for research. Somebody can sit to confirm, to know how many restaurants do you have in a particular street in Abuja. What is the total turnover of this restaurant from the report? And the digital system will allow people to know companies that are actually active, companies that are dormant, companies that are in liquidation, or that are in receivership at a glance. We'll put the status of the company so that anybody that wants to deal with a company at a glance will know whether I should deal with that company or not, depend from the status. Well, you don't expect us to achieve anything less, given the caliber of people we're interacting with. We are dealing. I'm happy to be in the midst of the best business lawyers we have in Nigeria, the SBL. So hopefully, God willing, some of these reforms will come into fruition this year. The remaining ones, God willing, before the end of next year, we'll have the full complement of these reforms in place. So these are my short remarks on that. Thank you.
Thank you so much, Mr. RG. I'm going to take some of the questions that were put up on the chat. One of them, I think I'll just read. I'll take 3 questions because of time, because we still need to deal with the poll. I think I should just read those questions, and then you can take them all together.
Okay.
Okay. So the first one says that a recent communique by the CAC on the guidelines for registering incorporated trustees creates an increased layer of difficulty. What is the reason for this, and of what value is it? Another question says, could the CAC adopt an e-certificate option for such that the certificate of incorporation is emailed to promoters? And then another question says, okay, there's a question on the KAMA bill, but you've answered that already. Another question says, why is the CAC saying that there must be prior consent for the registration of entities under Part C of KAMA? Isn't this an unnecessary burden, seeing that the pace of work at the CAC has been considerably slowed down in the past few months? So I think okay, let me take the last one. The CAC is operating both as a regulator and notary public, thereby adversely impacting lawyers' employment. If state counsel and corporate counsel are restricted from certain areas of practice, why is CAC usurping the role of notaries? So I'll let you take all those questions, sir, then we'll go to the poll.
Okay, thank you so much. I will start with the last. We don't actually notarize documents. Our officers do the declaration. We pay private notaries to notarize. And these are all part of the Ease of Doing Business initiative to reduce the cost of registration. But as I have said, this will soon go. With the new law, with the new KAMA, the requirement for statutory declaration will not even be necessary. The law has completely removed that. So very soon that will not be an issue again. On the issue of consent for incorporated trustees, this was actually part of our draft checklist that was circulated with SBL and other stakeholders. It was actually exposed on our website for about 2 months. We invited for comment. The major reason why we introduced that requirement is because of proliferation of organizations with obvious security implications. We are directed to restore the old system of vetting by security agencies for every application for registration of limited of association under Part C. We said that will impose an unnecessary burden on customers, because the challenge is sometimes names are proposed, objects are proposed, maybe without proper scrutiny. Some of these organizations are registered. I blame some of our staff for all this. But sometimes it's not easy to scrutinize at certain levels, because every application is done electronically. Not everything gets to the RG to look at before the certificate is issued. So the layer of authority at the level of on which these approvals are made, a lot of things have been overlooked. And to balance the concern of the security agencies and the concern of our customers, we said, okay, let's have this consent requirement such that any organization that may have obvious implication to national security, if you have regional groupings or religious groupings that may have implication to national security, you don't just give consent. You have to refer the application to the security agencies first until they give clearance. That is better than saying every organization, whether a church, an NGO that does civil liberty things, a religious organization, a regional organization, might be subjected to security screening. A lot of our colleagues that are less than 10, 15 years at the bar may not appreciate what I'm saying. In the past, registration under Part C takes an average of 1 year, because security agencies have to vet every trustee. They have to go to his village to confirm his identity, to confirm that he's of good character, that he's not an ex-convict. CSC replaced that with the statutory declaration. But if you notice, we've been in the media recently withdrawing certain certificates of registration for certain organizations, because those registrations shouldn't have been allowed in the first instance without recourse to security agencies. So to address some of this concern, that is why we now introduce this system. We understand the challenge. Very soon we are going to issue email addresses that such applications can be sent to. You don't need to submit it physically to our office. As I have said, we're introducing a mailing system. You don't have to visit CAC. Pending when we'll have a full digital system, documents will now be sent to us from first week of August through mail. through accredited courier companies. But for applications for consent and searches, you can send it by email with evidence of payment. We'll process, then you indicate the courier company that we should give it to. You collect it from there and pay them the cost of delivery. So these are some of the things we're looking at. And as I have said, these are genuine concerns. On e-certificates, this is actually part of what we envisage to do. Hopefully, the e-certificate will come into effect before the end of this year. We want to have an e-certificate for registration, e-certificate for change of name, e-certificate for every process. Even your CTCs should be electronic. We send you certified copies with electronic stamps. All you need to do to validate is we'll have a QR code that you can check to confirm whether that actually came from CAC or not. So these are some of the things, and I believe it will be achieved before the end of this year. Most of these reforms will be realized before the end of this year.
Thank you so much, sir. That's so encouraging to hear. We really look forward to seeing all these initiatives being implemented. We're almost out of time. We have just a minute, so I'm going to go to the poll. In the poll, we asked our audience, which digital initiative should the CAC adopt for maximum impact on easing the process of engaging with the CAC? We had 3 options. One was accepting electronic signatures on CAC forms. The other was enabling returns to be filed online and CTCs to be obtained online. And the last was virtual meetings. With 107 votes, or 54% of the votes, our audience has voted in favor of enabling returns to be filed online and CTCs obtained online. So that seems to be the most important digital initiative that our audience would like to see. Coming in second place with 36% is accepting electronic signatures on CAC forms. And in third place is virtual meetings with 10%. Thank you so much, sir, for your time. I would like you to, in closing, just comment on the outcome of the poll that indicates that what people would like to see most is that returns can be filed online and CTCs obtained online.
Yes, I want to give this assurance. I just don't want to be too optimistic. I will have said within the next 2 months. But you have our assurance that you'll be able to file returns, even get your electronic certificates before the end of this year. This is our assurance. Other things on electronic signature, by the time we have a unique password and access for every company, then that can also be done. So thank you so much, madam.
Thank you so much, sir. And thank you to our audience for your participation and your involvement in the polls and the chats. It has really helped to make this a very engaging session. Thank you.